Welcome to online class on Criminal Procedure Code. Let us discuss the provisions of Section 3. What Section 3 provides? Construction of reference. What is construction of reference? Why? Why such a section was included? Because after passing of the Criminal Procedure Code 1973, the executive and judiciary was completely separated. Previously, in some statute, there was this reference of magistrate. When there was reference in a magistrate in the code, in some section, then whether there may be confusion whether that magistrate is to be treated as executive magistrate or judicial magistrate. That has been clarified in Section 3. What it says? In this code, in the Criminal Procedure Code, any reference without any qualifying words to a magistrate shall be construed unless the context otherwise requires. When in the Criminal Procedure Code, somewhere it has been referred as magistrate without any qualifying word. What qualifying words means what? Whether executive magistrate or judicial magistrate. Simply it has been referred as magistrate. Then in such case, that will be treated as judicial magistrate. So what? In relation to an area outside a metropolitan area, that if it has been referred that magistrate in the area outside metropolitan area, that will be construed as judicial magistrate first class. In case of metropolitan area, that will be treated, it will be construed as metropolitan magistrate. What it says? any reference without any qualifying words to a magistrate shall be construed unless the context otherwise requires. If otherwise requires, that is a different thing. But in relation to an area outside metropolitan as reference to a judicial magistrate. So whenever it has been referred as magistrate without qualifying words, whether it is executive magistrate or judicial magistrate, so that will be construed outside these local limits of metropolitan area, that will be construed as judicial magistrate. Similarly, in reference to a metropolitan area, suppose magistrate reference to magistrate in reference to metropolitan area, that will be construed as metropolitan magistrate. Any reference to magistrate of second class, shall in relation to area outside the local limits of metropolitan area, that will be construed as judicial magistrate of second class. But any reference this second class magistrate of the second class, but not as judicial magistrate of the second class, any reference to magistrate of the second class in relation to metropolitan area will be treated as metropolitan magistrate. So that means in metropolitan area there will be no second class judicial magistrate. That means any reference to second class magistrate, reference magistrate of the second class in metropolitan, with reference to metropolitan area, that will be treated as metropolitan magistrate, not metropolitan magistrate. Now, never we say metropolitan magistrate first class. No, you would refer as metropolitan magistrate. Any reference to the magistrate of the first class shall in relation to metropolitan area be construed as metropolitan magistrate. Even magistrate of the first class, any reference to magistrate of first class in metropolitan area, that will be construed as metropolitan magistrate. So now you are clear, you should understand that any reference to whether there will be no second class judicial magistrate in metropolitan area. Any reference to magistrate of the first class or magistrate of the second class, that will be in metropolitan area, metropolitan magistrate. Outside metropolitan area, if it is magistrate of the second class, that is judicial magistrate of the second class. In magistrate of the first class, that is judicial magistrate of the first class. So, in relation to any other area, be construed as reference to a judicial magistrate of the first class, exercise jurisdiction in that area. So, in relation to any other area that is outside the local limits of metropolitan area, that will be treated as judicial magistrate of the first class. Any referred to the chief judicial magistrate, chief judicial magistrate, inside, so far as the area within this jurisdiction of within the local limits of metropolitan area, that will be treated as construed as chief metropolitan magistrate. But in relation to outside, in this code, only the context, any reference to chief judicial magistrate shall in relation to a metropolitan area be construed as reference to the chief metropolitan magistrate. In this code, only the context otherwise requires any reference to the court of judicial magistrate shall in relation to a metropolitan area be construed as court of metropolitan magistrate. So now you are aware that metropolitan area, metropolitan magistrate, metropolitan area is constituted as per section 8 of the Criminal Procedure Code. When the Calcutta, Bombay, Madras and Ahmedabad, the city of Ahmedabad were metropolitan area, and that is the population. If the population of a particular area is more than 1 million, 1 million, so in such case, that area may be declared as metropolitan area. Sometimes, if the population falls short, the state government by notification declare that that particular metropolitan area, that particular areas will cease to be metropolitan area. That we will refer in the latter section, that is in section 8. So now, previously there were also presidency magistrates and chief presidency magistrate. So that any reference to presidency magistrate, chief presidency magistrate shall be construed as metropolitan magistrate and chief metropolitan magistrate. To any area which is included in a metropolitan area as reference to such metropolitan area, and any reference to magistrate of the first class or of the second class related to such area shall be construed as referring to metropolitan magistrate exercise jurisdiction in such area. So now you are clear that there will be no magistrate first class or magistrate second class in metropolitan area. There will be only two types of magistrate, that is metropolitan magistrate and another chief metropolitan magistrate. But outside metropolitan area, we find magistrate, judicial magistrate of the second class, judicial magistrate of the first class, and chief judicial magistrate. That we find. Where now you should understand the difference. What is the how a person? What is the difference between the job of a judicial magistrate and the executive magistrate? Job of a judicial magistrate where under any law other than this code, the function exercised by the magistrate. So under the Criminal Procedure Code, the function is to be exercised by a particular magistrate, that has been specifically mentioned. But under any law, under any other law, the function is to be exercised by a magistrate. Function is to be exercised by magistrate. What is? Which involve the appreciation or shifting of evidence. Once the functions exercisable by magistrates under any law, functions to exercisable by magistrate, what relate to the matters which involve the appreciation of evidence, shifting of evidence, or the formulation of any decision. Suppose under any law there is a provision, the magistrate will take what appreciate evidence, or that what shifting means, some evidence will take and present it, shifting of evidence or formulation of a decision, or he will formulate a decision which express on any person to any punishment, and that decision which will expose that person for punishment or penalty or detention in custody. When order is to be passed by a magistrate that to punish somebody or to detain somebody in custody or to impose some penalty of some person or pending investigation, inquiry, trial, that would then penalty or detention in custody, pending investigation, inquiry, trial, or would have the effect of sending him for trial before any court, or the function of the magistrate is to send somebody to any other court for his trial. They shall, subject to the provision of this code, be exercisable by a judicial magistrate. What provides? How? Suppose specifically it has been mentioned that judicial magistrate will function or do this work, will do, has some power. This is to be done, this, then that is okay. But where under any other law, the functions exercisable by the magistrate, what involves the appreciation of evidence. The function involves the appreciating evidence, or shifting of evidence, or formulation of a decision. Thereby a person is liable for any penalty, for any detention in custody, or during pendency of investigation, inquiry, trial, or to send that person for trial before any court. Then in such case, it is to be exercisable, such powers are to be exercisable, such functions are to be performed by the judicial magistrate. So now you are clear? When a magistrate is required to take a decision by taking evidence or appreciating evidence or by considering some, that is, evidence, and thereby somebody is liable for any penalty, then detention in custody, pending investigation, trial, then, or you will be sent to another court for trial, then all such functions are to be performed by a judicial magistrate, not by the executive magistrate. Then what are the functions? Suppose we are under any law. Similarly, we are under any law, then this administrative or executive in nature, any function is administrative or that is executive in nature, which are administrative or executive in nature. That means the functions exercisable by magistrate are only administrative or executive in nature. What are those? Such as granting of a license. Suppose a gun license is to be issued, or a license is to be given to a dealer, a stampeder license is to be given, or the administrative of executive function, such as granting of a license, the suspension or cancellation of a license. Somebody's license is to be cancelled, suspended, sanctioning a prosecution. Suppose prosecution is sanctioned by the state. In such case, the function of the magistrate to give such sanction, or withdrawing from a prosecution. The magistrate will withdraw this prosecution. Then they shall, subject as aforesaid, be exercisable by an executive magistrate. So now you are clear. Then what is the job of a judicial magistrate? This judicial magistrate functions and to take decision whereby somebody is liable for any penalty or for detention in jail, or you will be sent to another court for trial, or sending him to police custody, all those things. But when the function of the magistrate under any other law is to take administrative or executive decision, executive in nature, that decision is administrative executive in nature, such as granting of license, cancellation of license, renewal of license, or sanctioning prosecution, withdrawing prosecution, etc. These are subject to the aforesaid. That is, are to be performed by an executive magistrate. By now you are clear. So section 3, what says? Construction of reference. Construction of reference where? That is, in the criminal procedure code, magistrate, the word magistrate has been referred somewhere without any qualifying word, then that will be treated as judicial magistrate. In metropolitan area, that will be treated as metropolitan magistrate. In outside metropolitan area, magistrate first class, magistrate second class, and chief judicial magistrate. So now this you are clear. Let us come to provision of section 4. Trial of offences under the Indian Penal Code and other laws. Most is Indian Penal Code, the general criminal law of our country. Under the Indian Penal Code, various or act various offences. Offences are defined and punishments are prescribed. Indian Penal Code defines offences and prescribes punishment. Apart from Indian Penal, this is general law, general criminal law upper country. Apart from criminal law, there is Indian Penal Code, there are other local laws for which there may be criminal action against a person and a person may be sent to jail. And so that is where, so for this taking decision to deciding a criminal case, a trial will take place. Then trial of criminal offences as per the provisions of the Indian Penal Code, then the criminal procedure code is to follow. But so far as other offences, other offences under other local laws or other special laws, if there is no specific provision for trial in a particular manner or taking of evidence or that is conducting of investigation in a particular manner, then that is to be done as per the provisions of Criminal Procedure Code. This is provided in section 4. What it says? All offences under the Penal Code, all offences under the Indian Penal Code shall be investigated, only investigated, inquired into, tried and otherwise dealt with according to the provisions herein after contained. What provides section provide for? All offences under the Indian Penal Code are to be investigated, tried, inquired into, or otherwise dealt into. Otherwise dealt into, suppose this, even after disposal, something is to be dealt of a particular, otherwise dealt into, then that is to be dealt with according to the provisions of this Criminal Procedure Code, herein after contained. Then all offences under any other law shall be investigated, inquired into, tried and otherwise dealt. 4 words. Investigated, inquired into, tried and otherwise dealt. Similar words are there. All other offences under other laws, under law, shall be investigated, inquired into, tried or otherwise dealt with according to the same provisions. Same provisions means according to the Criminal Procedure Code, but subject to any enactment for the timing and force regulating the manner or place of investigation, inquiry into, trying or otherwise dealing with such offences. What is subject to? Suppose under the Indian, this NDPS Act, a particular procedure is to be followed for the purpose of investigation. So that is to be followed. Suppose under the in NDPS Act, there is a particular provision that which restricts bail. So that is to be followed. So all offences under any other law means which offences are not punishable under the Indian Penal Code. All offences under any other law shall be investigated on the provisions of the Criminal Code as per the provisions of in not only investigated, inquired to, tried or otherwise dealt according to the Criminal Procedure Code, subject to any other special provision, if any, which has been prescribed under that law. So now you are clear. What is section 4? So, for trial of all offences under the Indian Penal Code, the Criminal Procedure Code is to be followed. For trial of other offences under any other law, Criminal Procedure Code is to be followed, but subject to any special provision for investigation, inquiry or trial of those offences in that special law. Now section 5, nothing contained in this code shall in the absence of a specific provision to the contrary affect any special or local law for the timing in force or any special jurisdiction or power conferred or any special form of procedure prescribed by any other law for the time being in force. So this is a saving clause. What it says? Nothing contained in this code, whatever has been contained in the criminal procedure shall, in the absence of a specific provision to the contrary, if there is no specific provision against it, against this saving clause, affect any special or local law. That to these provisions of Criminal Procedure Code will not affect any special or local law for the timing which is in force, or any special jurisdiction or power conferred or any special form of procedure. If a special power is conferred or any special form of procedure prescribed by any other law for the time being force. That if there is any other law which provides a particular special type of procedure to be followed for trial of a particular offense, or a special jurisdiction is, suppose for an example, there is special courts under the Prevention of Corruption Act, or suppose there is special judge for trying this SCST Act cases. So here, if there is no special provision to the contrary, this will, if any special provision is there, or any local law for the time and force which provides or gives any special jurisdiction power conferred or any special form of procedure prescribed, then that will not be affected as by the Criminal Procedure Code. Now this is there. Now, Constitution of Criminal Courts and Officers. This chapter 2 deals Constitution of Criminal Courts and Offices. What are the offices? These offices of the Assistant Public Prosecutor, criminal courts. How criminal courts are constituted? You are all aware that if that there are, which are criminal courts? Which are criminal courts? Sometimes it may come to your mind that criminal courts is Sessions Court, this magistrate courts, magistrate first class, magistrate second class, and executive. But sometimes you skip up that High Court is also a criminal court, or any other court. So that has been provided in section 6. What it says? Besides the High Court. Besides the High Court means the High Court is the criminal court. Besides the High Courts and the courts constituted under any law, under any other law, if a court is constituted, that is a criminal court. Besides High Court and any court constituted under the law, other than this court, other than the Criminal Procedure Code, special courts are constituted. Besides High Court and any other court constituted in either law other than the Criminal Procedure Code, there shall be in every state the following classes of criminal courts. Besides, that means High Court is also a criminal court. Any other courts constituted under any law that can be also treated as criminal courts. Besides them, besides these courts, there will be following types of criminal courts. What are? First is Court of Session, Judicial Magistrate of the first class, and in metropolitan area, Metropolitan Magistrate. Sessions, Court of Sessions, Judicial Magistrate of the first class, and in metropolitan area, Metropolitan Magistrate, Judicial Magistrate of the second class, and Executive Magistrate. So, Executive Magistrate is also a criminal court. So, that is 5 types of courts, 5 categories of courts are treated as criminal courts. First, High Courts or any other courts constituted under any other law as criminal courts. There will be following types of courts, that is 1, Court of Sessions, Judicial Magistrate of the first class, and in metropolitan area, Metropolitan Magistrate, Judicial Magistrate of the second class, and the Executive Magistrate. Now, section 7 defines that provides what is the territorial jurisdiction, territorial division. Notice has been jurisdiction is what is not used. It is territorial division. How there will be territorial division of the courts? What it says, every state shall be a sessions division. So first, every state shall be a sessions division or shall consist of sessions divisions. So that means, suppose, say for in the state of Odisha, either the entire state may be treated as a sessions division, or it may be divided into more than one session divisions. There we have sessions division. Every state shall be a session division or shall consist of sessions divisions, and every sessions division shall for the purpose of this code be a district or consist of districts. You should remember. So every state shall be a session division or more than one session division, and every session division will be a district, will be a district or consist of districts when there are more than that session division, different district, more than one district maybe. So for a session division, district is a must. So what it provides? Every state shall be a session division or more than one session division, but all session division must be a district or more than one session division, one district. Now, provided that every metropolitan area shall for the said purpose be a separate session division and district. So every state is a session division or session divisions, and session division must be a district or more than one district. Then every metropolitan area shall be a session division and a district under the provisions of the criminal procedure. Every metropolitan area. Now subsection 2 says, the state government may, after consultation with the High Court, alter the limits of the number of divisions and districts, such divisions and districts. That means the state government may alter the number of the session divisions and districts after consultation with the High Court. The state government may, after consultation with the High Court, divide any district. The state government, after consultation with the High Court, may divide any district into subdivisions and may alter the limits of number of such subdivisions. So, state government, after consultation with the High Court, may divide the district into subdivisions, and may alter the limits of the number of such, alter the limits of the local limits of the sub. Then the session divisions, districts, and subdivisions existing in a state at the commencement of this code shall be deemed to have been formed under this section. That means when the criminal procedure code came into force, all the session divisions, subdivisions, and districts which were functioning, which were in existence, that those session divisions, subdivisions, and districts are deemed to have been formed. Deemed to have limits of the number, deemed to have been formed under this section. This is section 7. Section 8. What is metropolitan area? You know, when a metropolitan area, you know, Calcutta, Bombay, Madras, Ahmedabad. But that is, those are declared as metropolitan area. But state government has power to declare any area, in a particular area as metropolitan area when the population of that area is more than 1 million or 10 lakh. So that is, the state government may by notification declare that as from such date as may be specified in this notification, from such date as may be notification, any area in the state comprising a city or town whose population exceeds 1 million shall be metropolitan area for the purpose of this code. This first subsection 1 provides the state government shall declare any area of whose population is more than exceeds 1 million shall be as from such date as may be specified in the notification as metropolitan area. The subsection 2 says, as from the commencement of this code, when this criminal procedure code came in 1st April 1974, Each of the precedent towns of Bombay, Calcutta, Madras and the city of Mohammadabad, residents of Calcutta, Bombay, Madras and city of Mohammadabad shall be deemed to be declared under subsection 1 to be a metropolitan area. That is, Calcutta, Bombay, Madras and Ahmedabad were deemed declared as metropolitan area as from the date of commencement of the Criminal Procedure Code. The state government may by notifications extend, reduce or alter the limits of the metropolitan area. So once a metropolitan area has been declared, state government has also power to alter the or reduce the area or this extend the area of such metropolitan area. But the reduction or alteration of area shall not be so made as to reduce the population of such area to less than 1 million. So now, subsection 4 provides, where after an area has been declared or deemed to have been declared Calcutta, Bombay, this Calcutta, Bombay, Madras and city of Ahmedabad, the deemed metropolitan area, or metropolitan has been declared by the state government when the population of that area exceeds 1 million and it has been declared that will be treated as metropolitan area. So in such case, then but after such declaration, the population of such area falls below 1 million. If the population of that area is reduced or falls below 1 million, then such area shall, and from such date, as the state government made notification specified in this year, cease to be metropolitan area. As because the population of a particular metropolitan area falls below 1 million, that will not automatically cease to be metropolitan area. But the state government, when such occasion will arise, such contingency will arise, then in such case, the state government may by notification specify in this way cease to be metropolitan area. May notify that particular area will cease to be metropolitan area. But notwithstanding such cease, if a notification is made seizing a particular area as metropolitan area, as the population of that area falls shorter than 1 million, even if when such notification is made seizing a particular area as metropolitan area, in such case, notwithstanding the cessation of that particular area as metropolitan area, the pending inquiry, trial or appeal will be done as if such cessation has not taken place. What it provides? But notwithstanding such seizure, any inquiry, trial or appeal pending immediately, before successor, before any court or magistrate in such area, shall continue to be dealt with under this code as if such seizure has not taken place. So that means when the state government makes a notification that a particular area will cease to be metropolitan area, as the population of that area falls shorter than 1 million, then that area will cease. Even if such a notification is made and that area ceases to be metropolitan area, but that will not affect, then the inquiry, investigation, even trial and appeal which were pending by that date will continue as if those cases were instituted in a metropolitan area. Where the state government reduces or alters under subsection 3 the limits of any metropolitan area, then limits such reduction or alteration shall not affect any inquiry, trial or appeal pending immediately before such reduction or alteration before any court or magistrate. And every such inquiry, trial or appeal shall continue to be dealt with under this code as if such reduction or alteration had not taken place. In this section, what is population? Population will be treated, that is population means the population as assorted at the last preceding census of which the relevant figures have been published. The last preceding population means the population which has been published that in last preceding census. Now, Court of Sessions. The state government shall establish a court of sessions for every sessions division. So, where a court of sessions court will be constituted? You know, every state shall consist of one session division or more than one session division. More one session division will be a district or more than one district. But state government will appoint. High Court never appoints a session judge. But in consult, the first appointment is always done by the state government. So after that, subsequent appointments, subsequent postings, etc. are done by the High Court. So here, the state government shall establish a court of sessions for every session division. State government will establish a court of sessions for every session division. Every court of sessions shall be presided over by a judge to be appointed by the High Court. This appointment doesn't mean the first appointment. So every High Court may also appoint an additional session judge and assistant session judge to exercise jurisdiction in court of sessions. Apart from that, the High Court may also appoint this additional session judge or assistant session judge. The session judge of one session division may be appointed by the High Court to be also the additional session judge of another division. One session judge may be appointed as the additional session judge of another division, and in such case, he may sit for the disposal of cases at such place or places in the other division as the High Court may direct. That is, if one session judge may be appointed as the additional session judge of another session division, and in such case, he will sit at such place as director, as notified by the High Court. Where the office of session judge is vacant. Suppose the office of session judge is vacant. What? Either his resignation or for transfer, etc., or casual leave. When the office of the session judge is vacant, the High Court may make arrangement for the disposal of any urgent application which is or may be made or pending before such court of session, which may be made before the court of sessions or which are pending before the court of session, then by an additional assistant session judge. So High Court may what? Vacant. When the office of the session judge is vacant, the High Court may make arrangement for disposal of the urgent application, disposal of any urgent application which are pending or which may be filed before that session judge. By whom? By the additional session judge or the assistant session judge. If there be no additional assistant session judge, by the chief judicial magistrate in the session division. And every such judge or magistrate shall have jurisdiction to deal with any such application. So every such judge or magistrate. That means when the office of the session judge is vacant, the High Court may make arrangement for disposal of the urgent application which are pending before the session judge or which may be filed before that session judge by the additional session judge or assistant session judge, or when additional session judge and assistant session judge are not available, then by chief metropolitan magistrate. When such an arrangement is made, such judge or magistrate shall have jurisdiction to deal with any such application. The Court of Session shall ordinarily hold its sitting at such place or places as the High Court may by notification specify. Then where the Court of Session judge will function, will sit, shall ordinarily hold its sitting. The Court of Session judge shall ordinarily hold its sitting at such place or places as the High Court may by notification specify. But if in any particular case the Court of Sessions is of opinion that it will tend to the general convenience of the parties, but in a particular case, if the session judge feels that it will is satisfied that for the general convenience of the parties and witnesses to hold its sitting and any other place in the session division, other than the place as notified by the High Court. It may, with the consent of the prosecution and the accused, that session judge, with the consent of the prosecution and the accused, sit at that place for the disposal of the case or the examination of every witness or witnesses therein. Explanation will make you clear. For the purpose of this court, the appointment does not include the first appointment. High Court may appoint session judge or additional session judge or assistant session judge. For the purpose of the court, appointment does not include the first appointment, posting or promotion of a person by the government to any service. First appointment either by posting or by posting or promotion, or post in connection with the affairs of the union or of a state, where under any law such appointment, posting or promotion is required to be made by government. If under any law such appointment is to be made, required to be made by the government, so that in such case the High Court cannot appoint a sessions or additional sessions or assistants for the first time. First appointment cannot be done. So we have covered. So section 10 says, assistant session judge will be subordinate to the session judge. But all assistant session judge will be subordinate to the session judge. But the additional session judge is not subordinate to the session judge. The session judge may from time to time make rules consistent with this code as to the distribution of business among such assistants. Who will make? Session judge may from time to time make rules consistent with this code according following this provision of the as to distribution of business among such assistants. The session judge may also make provision for the disposal of any urgent application. Now, when a provision arrange this, what is like High Court, this may make arrangement for disposal of urgent application by additional session judge or assistant session judge or in their absence by chief judicial magistrate. Similarly, the session judge may also make provision for the disposal of an urgent application in the event of his absence or inability to act by an additional session judge or assistant session judge or by chief judicial magistrate, and every such judge or magistrate shall be deemed to have jurisdiction to deal with any such application. When session judge makes a provision for disposal of urgent application which are pending before that court or which may be filed before that court, then by additional sessions or assistant sessions or chief judicial magistrate. So if such a provision is made, then such judge or such magistrate will be competent to deal with such application. Let us conclude, then we will go to the remaining section in subsequent classes. Thank you all.